the question be now put.
I'm going to hear Chris Farfoy.
Thank you very much, Mr Chair. Mr Chair, before I point to any particular clause in the bill, I'd just like to join my colleague, the Honourable Phil Goff, in saying that I think we've actually been witness to close to an Academy Award-winning performance from the Minister and the Chair, because she'd have us believe that her motivation for this bill is to improve the outcomes for children and families who are going through family court proceedings, that her motivation is to make sure that the outcome for many family court proceedings is in the best interests of the child. And we know that there's many people out there in the legal fraternity and those out who are assisting families get through this process don't believe it. Because, Mr Chair, Alfred Naro, I think, launched a gallant yet failed attempt to run a diversion for the Minister by talking about some of the submissions that were heard in the Select Committee. And very selective was Mr Naro, but I would also like to take the opportunity to to show, or to at least read out some of the submissions that came from the Christchurch Family Court judges, people who I think would know this process relatively intimately and certainly wouldn't want the justice system clogged up with unnecessary cases. And to say that this government wants to make this process easier for families and much better for children, the Christchurch Family Court judges don't buy. And I read from their submission, whoever gave it, it was on behalf of the Family Court judges. He said, "I intend to speak plainly in the short time available." He said, "I speak on behalf of the Family Court judges of Christchurch. We recognise the driving force behind these reforms is to cut state expenditure on the family court." So this is the Family Court judges recognising that the motivation isn't to make things better for those going through the process, but to cut state expenditure on the family court. They said, "In our opinion, the effect of the reforms will be the reverse, to increase state expenditure arising from the relationship breakdown." So there we have it, submission to the Select Committee on this bill from Family Court judges in Christchurch, fully recognising that the main motivation of this bill is not to make the process easier or outcomes better for children or their parents, but is to cut state funding, and they think it will do exactly the opposite. And that is the Family Court judges in Christchurch, Mr Chair. Mr Chair, Clause 4 does point towards the child's welfare and best interest to be paramount in this process. But through this process, since the bill was introduced, there have been a number of people who simply haven't thought that this piece of legislation will achieve that. And when this piece of legislation was submitted late last year, I believe in October it was, Professor Mark Hennigan from the Otago Law School said of, I think it is Clause 7, I believe, of the ability of not to have mandatory child legal representation, said this in a media report. He said, "Much of the fight is often about children, but if you take their representation out, then we doom them not to be heard." And I think the end of that quote from Mark Hennigan is quite apt. If we take out their representation, then we doom them not to be heard. And we heard from the Minister and the Chair at the same time that she was okay with that. She said, "The current situation where pretty much every child gets a lawyer is overkill and frankly is not necessary." That's what our Justice Minister said at the time of the introduction of this bill. And there is great concern about those comments and this bill to what she said at that time. Mr Chair, I think as many colleagues on this side of the House have said that there was an attempt to strike a balance between maybe getting some cost savings and improving the family court process. But over time, when this bill was introduced, and I think just before this bill introduced, there was certainly, and I felt it in my community, a concern about what might arrive on the table when this bill was tabled. And those concerns were valid when this bill arrived here in Parliament, because, and I just want to make sure I I mentioned the name Katrina Doyle from a family law specialist in Porirua, who came to me almost instantly as soon as this bill was introduced with her concerns around this bill. She called a public meeting in Porirua, which was quite well attended, also by my Green colleague Jan Logie, who was based in Mana, and it was quite a full meeting, and a lot of... Mr Chair?
Paul Goldsmith.
Mr Chair?
I move that the question be
I
now
over
put.
here from Andrew Little.